In Zimbabwe, a residential stand is more than just a piece of ground. For a teacher, a nurse, a young family, it could be security, a place to build, a place to live to your children, and a way out of renting forever. That dream is why affordable housing schemes matter. But what happens when people pay month after month for a stand and years later they say they still do not have the land they believed they were buying? This investigation looks at housing schemes associated with River Valley Properties and Mahlaba Housing Programme, Mabula in Zvishavane and Lower Rangemore 27A in Bulawayo. Some beneficiaries have made serious claims of undelivered stands and long delays. River Valley is publicly described both projects as progressing, so this is not a video declaring anyone guilty. It is an attempt to answer a harder question. When ordinary people pay for a housing stand, what protections exist if the land, approvals, infrastructure, or delivery timetables becomes uncertain? In February 2014, Newsday reported that River Valley was launching a low-cost residential stand scheme intended to benefit more than 5,000 civil servants. The reported structure was accessible by design, an initial payment of 100 United States dollars, then $50 monthly, with the balance payable in installments while beneficiaries built. For someone who could not afford a large deposit, that proposition was powerful. Pay gradually, secure a future stand, build step by step. But a payment plan is not the same thing as a secure ownership. A buyer needs to know who owns or controls the underlying land. Has it been lawfully allocated? Is the layout approved? Are engineering designs approved? Who will install roads, water, sewer, and electricity? What does the agreement actually promise and by what date? Those questions may sound technical, but they are the difference between buying a future home and buying into uncertainty. The Bulawayo story shows why these questions matter. In 2014, reporting described Mahlaba Housing Programme through River Valley Properties developing stands intended for thousands of civil servants on land connected to Helenville Block. Another company, Gamange, disputed River Valley's right to develop the property and the dispute reached the High Court. At around the same time, the government notified the court that it intended to compulsorily acquire the wider property for urban development. River Valley's position in the litigation was that the land had been gazetted for acquisition. Ordinary prospective homeowners could be paying into a housing scheme while the rights surrounding the underlying land were being contested. In 2018, 24 teachers brought a legal claim against Mahlaba Housing Programme trading as River Valley Properties. According to published accounts of the case, the teachers said they joined the scheme in 2014 and 2015, paid monthly contributions, signed agreements, and received allocated stand numbers. They alleged that the promised stands did not physically exist or existed only on paper. They withdrew from the scheme and sought refunds, reported at 15,845 United States dollars. The court materials also helped establish a corporate connection central to this story. Mahlaba Housing Programme was identified as trading as River Valley Properties, and Smeli Dube was identified as a director in the related court record. It does show that concerns over promised stands and refunds had moved beyond informal complaints and into the legal system. Now comes an important complication. In a separate Hertfordshire land dispute, the High Court found that the land in question had been acquired by government and allocated to Mahlaba Housing Programme for residential development. The court also found out that a writ relied upon to evict beneficiaries was a nullity. The record shows a complicated environment, state allocations, private claims, court challenges, local authority processes, developers and beneficiaries, often all connected to the same land. And when the system goes wrong, the person with the least information is usually the buyer making monthly payments. Mabula is in Zvishavane, and a government or council project bearing the name Mabula should not automatically be treated as the same thing as River Valley project using the same location, because reporting from 2014 and 2015 described a major government and local authority linked Mahlaba Housing Estate initiative in Zvishavane, involving roughly 8,000 to 8,100 stands being serviced. Separately, River Valley has publicly described Mabula in Zvishavane as one of its housing projects. The unanswered question is whether River Valley's Mabula project was part of that wider development, a particular portion of it, a partnership, a separate project in the same area, or simply a project using the same geographical name. The clearest recent beneficiary reporting concerns Lower Rangemore 27A in Bulawayo. In April 2024, site reported that more than 400 civil servants said they had been paying since 2014 for 300 square meter stands at Lower Rangemore 27A. Some beneficiaries told site they had first been shown stands at Cowdray Park and were later directed to Rangemore. Pindula again reported that beneficiaries said they had waited for more than a decade without receiving their promised stands. The question here is simple but urgent. What did each beneficiary's contract guarantee? What had been delivered at that time? And what exact remedy was offered to those still waiting? River Valley's own public statements form an essential part of the record. In January 2025, River Valley's chief executive Smelly Due told the Zimbabwean Independent that Mabula in Zvishavane and Lower Rangemore 27A in Bulawayo were shaping up. The report said the projects were intended to provide stands for approximately 3,500 homeowners. This is not an allegation against the company. It is the company's public description of its own projects. But it creates a fair follow-up question. What did shaping up mean in the practical terms? Roads, water, sewer, title process, and what had been completed when beneficiaries later said they were still waiting. The company has also published a 2026 Mabula update featuring its Zvishavane housing office. River Valley also issued a notice to Mabula clients about closing its Zvishavane office and directing them to its Gweru head office, including a statement about reimbursing bus transport costs. An office closure does not prove misconduct. Businesses close offices for many reasons, but for clients with unresolved housing questions, it makes transparent communication and accessible records even more important. River Valley has itself been the victim of unauthorized stand sales. In the Hertfordshire matter, people were prosecuted for selling River Valley stands without authority. In a 2025 reported conviction, the court ordered a restitution of 85,000 United States dollars to River Valley. Earlier reporting also described allegations that individuals used site plans and maps to sell stands associated with the company without permission. This matters because a person said, "I paid for a River Valley stand," does not automatically establish that River Valley received the money, authorized the sale, or made the particular promise. That must be checked receipt by receipt, contract by contract, and site plan by site plan. It also points to a wider consumer protection problem. Buyers can be harmed not only by delayed development, but also by middlemen and land sellers who lack authority. The most useful question is not who do we assume is guilty, it is who received the money, what authority did they have, what land was identified in writing, and what independent record confirms. There is another point that must be stated plainly. In 2022, the National Prosecuting Authority declined to prosecute Smelly Due over separate fraud allegations concerning state land, citing lack of evidence. At the same time, it does not by itself resolve every civil dispute, every beneficiary complaint, or the delivery status of Mabula and Lower Rangemore. Mabula and Lower Rangemore are not only stories about one company. They are a window into a broader Zimbabwean risk. A buyer can pay for a residential stand and still find that the land is disputed. the seller lacks authority, the plans are not approved, the infrastructure is incomplete, or delivery is delayed beyond recognition. Buyers can lose money even when they pay an institution that appears legitimate if that institution does not have the legal right to dispose of the land. Other reported stand sale cases across Zimbabwe show another version of the same danger. A person may sell land they do not own, land they have no authority to sell, or the same stand to more than one buyer. These cases are not proof that every housing development is fraudulent. They are proof that a signed receipt alone is not enough protection. For Mabula in Zvishavane, the key questions are: what exact parcel of land was River Valley developing? What legal interest did it have in that land? Was the project part of a larger Mabula estate, a section of it, or separate? Which approvals had been obtained? How many clients had paid? How many had been allocated? And how many had received serviced stands? For Lower Rangemore 27A in Bulawayo, the questions are equally specific. What did the 2014 agreement promise? Were the beneficiaries moved to Cowdrey Park? And if so, on what terms? What progress was made on servicing? How many people received stands, refunds, substitutions, or formal delivery dates? And what remains outstanding? For local and national authorities, what approvals were granted? What land records and layout plans can be made public? What oversight exists before people are allowed to pay deposits or monthly installments? And for the beneficiaries, who exactly took each payment? Was it paid directly to the company through an employer deduction or to an agent? Is there a receipt, a contract, a stand number, and a site plan? These details matter because the remedy may depend on them. The story of Mabula and Lower Rangemore is not yet a story with one clean ending. The available record contains beneficiaries who say they paid and waited for years. It contains litigation, land disputes, and calls for refunds. It contains River Valley's public statement that its Mabula and Lower Rangemore projects were progressing. It contains a company update to Mabula clients, and it contains documented cases in which River Valley itself was harmed by unauthorized sales of its stands. Those facts can all be true at the same time. What remains unanswered is whether every person who paid was matched to a real, authorized, and deliverable stand, and if not, what remedy they will receive. This investigation is not an invitation to harass anyone. It is a call for documents, clarity, and accountability. If you represent River Valley, a local authority, or any party named in this story, we invite a detailed right of reply. The questions are on screen and the public deserves clear answers. Because in a country where a stand can represent a family's entire savings, pay now, wait later cannot be the system. If you found this helpful and interesting, make sure you click the like button, subscribe to Introverted Chronicles so that you are notified each time that we post a new video. Thank you for watching. I will see you in the next one.